I welcome you. I represent the voices of our council members to welcome you to this abrupt, or we can call it impromptu press conference that is happening right now at our ULS house. I bring you apologies from our president, from our vice president, and council members for not starting in time like we had promised you through our call. We call for your apologies. I mean, we apologize to you for that, and we request you that you bear with us. Our president will be joining us shortly because of the time zones of where he is. Right now, we all know that he's not in the country, and therefore we shall a bit wait for him, and he will talk to us in the next moment. Our vice president is also not around, but he's joining us, and he's going to join us shortly, but he's following the event. He's attending a sick relative, and upon allowance by the doctors, he will also be joining us. Ladies and gentlemen, we shall be having our most perpendicular treasurer, the governor, Mr. Isiko Arthur, who is joining us just shortly. And allow me, with great pleasure, recognize the presence of our council member, Eastern Uganda, that is Advocate Edina Nguru. He's already in the building, and he will also be joining us to present. We also have our council member of Western Uganda, that is Advocate Sam Muhumza, who will be joining us online. Then our presenter of the main council message, that is our council member central, Advocate Alexander Lule, is soon catching up with us. I request that we give him some moment. He's about to join us, but he will be presenting the main council message. Thank you so much, ladies and gentlemen. Today, as I said, council is presenting a very important concern in matters pertaining rule of law, and that is the recent promise by the judiciary to enact a mobile court, and our council will be weighing in on its, may I use the word ramifications, on constitutional rule in matters pertaining the law. If I can take you through how this journey has been since the 2nd of April, where the killing of the babies, of the 4 babies in that Ggaba school was reported. Very many things have been happening, and especially those things have been raising matters, legal questions, which cannot make our council keep quiet or challenge them or express where there is illegality. It can't keep them mute. And the first one was on the 2nd of April, when those children were reported murdered by the suspected assailant, whom we all have heard of. Some of us we have already seen. And on 4th April, there was a statement by the State Minister for the Youth and the Children, that is Honorable Baram Barugahara. On 6th April, there was a Requiem Mass, where the Honorable also issued out some statements, especially via his official X account, Baram Barugahara. And then on 7th of April, the principal judge, the former director of public prosecutions, Lady Justice Jane Francis Abodo, unleashed that intention of how they want to handle the matter, something which I will leave, yes, our council member, the treasurer, that is going to comment on it. Then on 8th, the suspect was presented in court, in Makinde Chief Magistrate's Court, and I know some of us went there and you covered the event. Then on 9th, the day that followed, the suspect was committed to High Court. Recently, they want to amend the Magistrate Courts Act. Now it is a bill, it is not yet the act, but they want to amend it. And I think one of the things that the Radical New Bar was raising and was applauding was removal of the committal processes. So this suspect was committed to the High Court on 9th, and then that was followed by a post by the Minister Barugahara, also making some statements which the Radical New Bar deems legal and which should not be uttered by him. Then the response by all these series of events was met by a reaction from the Radical New Bar through a statement signed by the Radical New Bar president, and largely it was holding matters of constitutional preservation and especially the presumption of innocence as envisaged in the Constitution. Then, after that, the Radical New Bar awaited the response from the judiciary on how the matter will continue to take course, and eventually on 11th April, that was yesterday. Today is 12th? Yes. Yesterday, the judiciary did a communique through their official X handle, the Judiciary Uganda, and they talked about how they would handle the matter through a mobile court. And actually, they said the court sitting would take place within the precincts of the scene of the crime, and that eventually leaves no room for the Radical New Bar to express their comments, their reactions, their weighing in on the legal gimmicks, the questions, the whatever that they wish, they deem to express, and thus making today's press conference inevitable. In one of the Minister for the Youth and Children's tweets, there is where he predetermined that the trial of the main suspect would commence on 13th, that is tomorrow. And according to the Radical New Bar, that's not viable. That does not work in the rhythms of the rule of law, where a minister predetermines the date when a case must, because he said it in one of his former tweets, and then eventually we see the judiciary fixing the same date. Therefore, that one means there is some interconnection between the two. The other one belongs to the executive, the minister, not so, and then the judiciary. So these are two arms of government. But excluding the cornerstones of the rule of law, who are the lawyers, the bar. So that raises questions which cannot also keep the Radical New Bar silent. In this case, allow me take this opportunity to welcome our council member, Eastern, that is Council Eddie Nanguru, to greet us as we see the proceedings of this event. Thank you so much. Council Eddie, come and greet the press.
Good afternoon. Is this the best sound we have? Seems a bit deep, but I will accept it. My name is Eddie Nangulu. I am the council member representing the Eastern region. I want to begin by thanking everybody that has made time this afternoon to be present for this press conference. It's important because it is coming on the eve of what may be the most recent institutional form of mob justice. We have seen mobs decide the fate of suspects at their own discretion. For the first time now, it is institutional, that we are having a number of institutions converge. The DPP, judiciary, the police, number of other stakeholders converging to lynch a suspect of a crime. Now, the Radical Ggaba is the strongest advocate for speedy trial. We began this advocacy when we were pushing for the amendment of the Magistrates Courts Act to abolish committal proceedings, because we had said in many ways that it is not right for committal to happen. Why is someone supposed to appear before a court lacking jurisdiction and then spend 6 months to 2 years before they are sent to the High Court? This recent event is a stark contrast from what we have been demanding. We've been demanding for a speedy hearing, but not an abusive process like the one we are witnessing. In one day, a man who is perceived not to be in his right frame of mind is supposed to stand trial, and this trial is supposed to happen in the hearing of the public. Now, the law provides for public hearings, but this is a unique session because going to the scene of crime when the wounds of the victims are still fresh. Some of the babies or some of the children, some of them maybe have just been buried. And then you return to that point there. The judicial process cannot be dealt with in such a manner. Ideally, the court shall be increasingly overwhelmed by the pressures of the public, by the pressures of the parents, by the pressures of everyone who is witnessing. I pity the victim. I pity those who will even defend him, because under any circumstance, any question you ask will be answered with scorn, rebuttal, and chants from the public. In our opinion, this is not and should not be a proper process. As Adam was saying, the Minister Balaam came out and said the suspect should be shot dead at the city square. And he kept repeating. Now, this rhetoric here is against our constitutional framework. It can't be permitted that a leader, a minister, can come out and say that before one has gone through due process, that they should be subjected, that they should be condemned. Now, the public has largely already condemned, and the minister's demands equally assert pressure, an uncomfortable situation for anybody who is keen on the rule of law and justice. We've called this presser this afternoon to share with you our statement. I was just giving you a heads up on what we are disturbed about and why this Sunday wouldn't be like any other Sunday that we are going to church and we are going for prayers. Tomorrow, Monday, we are going to witness institutional mob justice, and each one of us must stand up against such practices before they take root. Now we have a statement prepared, and I want to thank you for having been patient. I will request for a short while, and if the person who must read it isn't here, I will read the statement, just so that I do not destroy or have your Sunday lost completely. Yes, I see a hand. Yes, good afternoon. Yes.
What do you mean by that?
Well, let me begin with the second question. Under our legal framework, a person shall only stand trial when they are of sound mind. Where there's any presumption of insanity, that person there cannot stand trial. Now, we have undergone a rushed process. It is rushed because of the pressures involved. And we equally decry the death, and we condemn the death. But we also shouldn't cast our laws aside. We have received reports that the suspect wasn't acting on his free will. Now, those reports, of course, must be subjected to thorough medical examination. But because of the lynching by the mob, any willing either doctor or whoever would examine him would succumb to the pressures and pronounce someone as mentally stable. The minister came out saying, how do you be of unsound mind and yet you hold a mobile money pin? A mobile money pin is held by anybody. You need not be mad completely and walking on the street naked. There are incidences of mental sanity, even where the lapses occur. As long as somebody has a lapse and it can be proven, you will not condemn them before they are properly examined. Now, on the second issue of the mobile courts, now the intention was designed to reach the most unreachable places, the islands where there are no courts, the farthest points in the country. The spirit of the mobile courts was to extend justice, but not to offer opportunity for the public to assert pressure on the rule of law and judicial system. So it is being wrongly applied. The principle is being used now to achieve either political or individual gains, and that is wrong. That is why we are condemning this specific mobile court city. Okay, those are the answers for those questions there. I will let's have a 5-minute recess, and I will deliver the statement if the person assigned isn't here. So I will again pray for your patience. Adam, maybe you could give us for those online, you could give them a short music interlude as we wait for the 5 minutes to lapse. Thank you so much.
Yes, thank you so much, ladies and gentlemen, for your patience. Yes, allow me at this point of time to give you what triggered this council to summon this press conference, especially the utterances or how what we call responsible government officials responded after it happened. One, the first one is a tweet by the Honorable Minister. Yes, live stream. I request that you flash that. Yes, that is it. We can all see, we can all read. That is the Honorable Minister for the Youth and Children Affairs through his official X handle. See what he's saying. Such suspects deserve death. We should not hide behind human rights or continue protecting criminals. The Minister for Youth and Children Affairs calls for swift and tough punishment for the Ggaba children's killer. That was via UBC television. Then next are the statements said by the minister himself. Live stream. That was on 4th April. The statement by the same minister. Yes. Yeah, that is part 2. You bring part 1. Yes, the minister himself, on the 6th of April, he says that this afternoon, in the presence of the Minister of Kampala, Honorable Hajat Minsa Kawanda, hundreds of pastors and thousands of mourners, I represented His Excellency the President YK Museveni and Mama Janet Museveni at the memorial service held at Ggaba Community Ministry compound. I conveyed His Excellency's heartfelt condolence message and extended contribution of shillings 10 million to each family that lost a baby during the incident, in a spirit of solidarity with the grieving parents. His Excellency assured the mourners that security will remain a top priority and that justice will be served to the criminal now in detention. The Lord is close to the brokenhearted and saves those who are crushed in spirit. He referred to Psalms 34:18. Then on the 7th of April, there was an interview, a press conference, where the current principal judge, Lady Justice Jane Francis Abodo, was, and NTV got her, and this is what she had to say. This is NTV's tweet. Jane Francis Abodo, the principal judge on the Ggaba murder case. The president says this case must be handled. Can you test the mobile court directive you made as the judiciary? Take the court to where the incident happened and handle the case there, and handle it fast. That was a tweet by NTV. And then from that, there was a tweet by the minister himself on the very day when the ordeal happened. And this is what he says: we extend our sincere appreciation to the joint security forces, including the CID, JAT, crime intelligence, and other intelligence agencies for their speedy, thorough, and comprehensive investigations through the tragic murder of the nation's children in Ggaba. We also express our gratitude to the Lord Chief Justice and the entire judiciary for allowing an expedited trial for the suspect in the recent heartbreaking killings of infants in Ggaba. In response to public demand, the proceedings will be held in open court. The trial is scheduled to commence on Monday, 13th April, and will run for 1 week. Court sessions will run daily from 9 a.m. to 4 p.m. Members of the public are invited to attend. Please note that sitting within the courtroom will be limited to 1,000 people on the first come, first served basis. Once proceedings begin, no further entry will be permitted. To ensure wider public access, screens and speakers will be installed for live viewing, and the trial will be broadcast on major television stations. For security and convenience, attendees are advised not to carry bags or any unnecessary items. Parents and members of the general public are encouraged to participate as we collectively uphold and support justice to all Ugandan, for all in Uganda, particularly within Kampala. In line with public demand and the guidance of His Excellency the President, the trial will also be held publicly at the scene of the crime, Ggaba Community School grounds. Thank you. That was the Minister of State for the Youth and Children Affairs, Honorable Baram Barugahara. Then also, there was a tweet by the judiciary, which was yesterday, 11th of April, and this is it. The judiciary has intensified preparations for the first ever mobile court sessions to be held in Kampala, scheduled to start on 13th April 2026 in Ggaba Makindye Division. Yesterday, the Deputy Registrar of Criminal Division, His Worship Tuachire Samuel, chaired the preparatory meeting in Ggaba to coordinate arrangements for the special court sitting, which will take place at the Ggaba Community Church grounds. The historic session marks a significant milestone in the implementation of the Constitution Operation of Mobile Courts Practice Directions 2026, Legal Notice 1 of 2026, recently issued by the Chief Justice. The directions provide a formal legal framework for courts to sit outside designated court premises where circumstances so require in order to enhance access to justice improve efficiency in case disposal, and respond to unique situational demands. This initiative is part of the judiciary's broader transformation agenda aimed at taking judicial services closer to the people, particularly in matters of high public interest or where interests of justice necessitate proceedings being conducted within affected community. The session will handle the case of Christopher Okello Oyum, the prime suspect in the Ggaba toddler killings, who was committed to the High Court to stand trial on 4 counts of murder. The matter will be heard by Justice Alice Komuhanji Kawuka. The tweet continues. Yes, at this point of time, the reason why the press conference has been urgently convened is because it reflects the day which was formally recited by the minister. The council will comment about that. The treasurer will be giving us reactions, and then our council member representing Central will be delivering the statement, and according to my observation, I can see him here. So at this point of time, I will invite our council Eddie to come back and you take over. Yes, let me invite our council member representing Central to invite the president to make his remarks as we proceed. Thank you.
Our comrades that are following Zander, please, let me pass on to you the microphone.
Thank you, colleagues, the viewers, the listeners, the ones following on live. Thank you for being accommodative to all of us and this agency. Without taking a lot of time, I would request to invite the team, the IT team. The IT team, can you please put on the president? Adam, is the president on? Okay, as we are waiting for him to get connected, I really don't have a lot to add on what the previous speakers have already said, but a key word and a key phrase is that justice, much as justice has to be hurried, we have a phrase that goes by, justice delayed is justice denied. However, justice also hurriedly, like this one we are seeing, is justice denied. Like my colleague was telling you, this person's mental status is not yet ascertained. There is really very short time in between the incident, from the time the incident happened up to when the trial is beginning. We doubt whether all that has been done. We doubt whether the defense team has already been given disclosure, all those nitty-gritties. But anyway, that is the reason as to why we are going to give you our statement in full. I think now we can go to the president. He has been connected. Can we turn all our cameras to the screen as we hear from our president, Senior Counsel Semakadde Chimaze Isaac.
Yes, Mr. President, can you hear us? Mr. President? Mr. President?
Everyone can hear me, Adam. You're the only one who can't hear me.
Mr. President, you have just talked. Okay, thank you so much. Mr. President, you can take on.
Can you hear me?
Yes, yes, you are very loud and clear.
Finally. Well, I guess I should say good afternoon to my colleagues in council who have made the effort to come into service of the bar on short notice this Sunday. I thank you very much. Council member for Eastern and council member for Central, Mr. Eddie Nangulu and Mr. Alexander Dule, I have taken note of your presence. And I thank you for holding fort on my behalf in this constitutional moment. I would also like to thank those who have joined online. I can see the Vice President is here, and I can see Sam is also online. I don't know where the other council colleagues are, but I did hear you, Adam, present apologies. Apologies, or you clarified that they will be here. So that's very important. For our colleagues in the media who have come, I present compliments for your steadfast commitment to the profession and to your profession and ours. This is not a simple subject to talk about. We are convened here to speak on a situation that confronted our ancestors 24 years ago. In the year 2002, somewhere in Kotido, there was a field court martial trial conducted, of course, by the military in respect of the alleged murder of Father Declan O'Toole. The Uganda Law Society went to court, to the Constitutional Court then, to complain about what had occurred in Kotido. A fast-track justice that had been reported about. The government defended it as ordinary part of the SOPs for the military. And so a constitutional question was framed for the Constitutional Court to determine whether the military was beyond the reach of the Constitution in some of its quote-unquote standard operating procedures, including fast-track trials that our president likes to call one of the hallmarks of their time in the bush. Bush war trials, bush trials. We received the decision, and it's important that we talk about this decision. Now, recently, the judiciary passed the mobile court guidelines, and I thank Councillor Nangulu for speaking about it today. So we are also going to talk about mobile courts. The concept of mobile court is not new, it's not an initiative, it's not an innovation, the judiciary. It is actually something that was requested for by court users in specific zones and circumstances. But now we see that its first use is as a political weapon to appease the establishment and not to do justice to those whom it was intended. I shall say more about this, but this is a judicial offense. We will also speak about the minister's error. I think my brother touched a bit on it. Minister for Youth and Children Affairs has been all over the map on this since the 2nd of April. We will then give the position of the bar and recommendations of the bar. I would like to note and remind the media who have come that this is further evidence of what we complained about in Executive Order R&B number 7 of 2026. Our Uganda State Executive Order declaring the GMO Chief Justice, Flavian Zeija, a global pariah. We told you then, and we repeat it now, that we shall catalogue violations of the Constitution by the Chief Justice himself, in which he is dragging the whole of the judiciary, preventing us, putting us at an embarrassment. Like, where do we then challenge this constitutional violation? By the judiciary itself. We warned you that we shall have to litigate the case against our Chief Justice and against our judiciary internationally, because there is no courtroom in which to challenge this. So we shall have to use alternatives, ordinary courts. So don't expect that this is the last you've heard from us or you hear from us on this matter. Without further ado, I have asked Councillor Nangulu a demand to deliver my remarks ahead of the official position of the bar, which is signed by everybody. So Nangulu, Mr. Nangulu, if you're ready, please come and deliver my remarks, take the media through down memory lane. What happened 24 years ago, and what are the parallels with today, and what is the problem, what is the judiciary offense? Our first catalogue of the GMO Chief Justice's errors that we are making public since we issued Executive Order number 7. Please, Nangulu, if you're ready. That is, I will speak more in answering questions later. I think that's a better use of time. Thanks.
Okay. Forgive us for having to move you back and forth. Gentlemen, if I could have your attention. If I could have your attention, please. I have before me the remarks by the ULS President. The same is dated Sunday, 12th of April, 2026. The title: A direct parallel to Constitutional Petition number 2 of 2002, ULS versus Jackson Karugaba and the Attorney General. From the public pronouncement of Honorable Minister Balaam Barugahara, since 4th of April 2026, and the judiciary's own statement of yesterday, 11th April 2026, the ULS is dismayed to learn of the first ever mobile High Court session at Ggaba Community Church grounds commencing tomorrow, 13th April 2026. This orchestrated spectacle is not novel. It is a civilian echo of the very constitutional violations the ULS successfully challenged and the Constitutional Court condemned in petition number 2 of 2002, consolidated with petition number 8 of 2002. In that case, 2 UPDF soldiers were arrested, tried by the field court-martial, convicted, sentenced to death, and executed on the same day for the murder of 3 civilians in Kotido district. The proceedings were driven by public outrage and the operational necessity. The ULS petitioned that process. The ULS petitioned that the process violated Article 28, which is the right to a fair hearing before an independent and impartial tribunal, adequate time and facilities for preparation of defense, and Article 28 and Article 128 on judicial independence. The Constitutional Court, in its judgment of 5th February 2009, held unequivocally: 1. The Constitution applies in full to every judicial process, including military tribunals. Military courts form part of the judicial system of Uganda and are therefore governed by Article 128 of the Constitution. It is structurally impossible for such tribunals to be independent and impartial, given the current laws which they are constituted and the military structure within which they operate. The right to a fair trial cannot be sacrificed to speed, public emotion, or external direction. Every accused person is entitled to adequate preparation time, an unprejudiced forum, and protection from prejudicial publicity. Even in the heat of public outrage over heinous crimes, the presumption of innocence and the separation of powers must prevail. Justice Chinomu Juni, as he then was, delivered the lead judgment, declaring the field court-martial proceedings unconstitutional precisely because they subordinated judicial power to executive and situational pressure. The parallels here are stark and damning. Then, as now, a heinous crime inflamed by public sentiment. Then, as now, speedy justice was demanded and delivered outside ordinary safeguards. Then, as now, the tribunal's independence was compromised by the very structure and context created to satisfy that demand.
Here, at the same time, on the same explain, the one which you found him working with him the other day.
If I may just repeat. Then, I am just listing the parallels between the two situations. Then, as now, a heinous crime inflamed public sentiment. Then, as now, speedy justice was demanded and delivered outside ordinary safeguards. Then, as now, the tribunal's independence was compromised by the very structure and context created to satisfy the demand. The only material difference is that in 2002, the violation occurred in a military forum. Today, it is being replicated in a civilian high court session, deliberately relocated to a crime scene at executive behest. The Constitutional Court's reasoning binds with equal force. A mobile court summoned to the churchyard where the victims were mourned, under live cameras and ministerial oversight cannot satisfy Article 28 or 128 any more than the Cotido Field Court Martial Code. We condemn this in the strongest terms. The judiciary's conduct, as announced yesterday, represents an unacceptable institutional cover for the most cynical executive interference in 24 years. The judiciary has descended into the political theater. This is unacceptable. The judicial offense. The mobile court as a political theater. The judiciary's communique confirms that on 13th April 2026, Justice Alice Komuhanji Kauka will preside over a mobile high court at the Ggaba Community Church grounds to try Christopher Okello Onyum on 4 counts of murder. It brands the sitting historic and invokes legal notice number 1 of 2026. The ULS finds this session unconstitutional, unsafe, and a calculated fraud on the public for the following reasons. The first reason, a court convened by executive fiat, not judicial necessity. The Constitution, operation of mobile courts practice directions authorize mobile sittings only where circumstances so require to enhance justice, to enhance access to justice and efficiency. No such circumstances exist in the instant circumstances. The High Court Criminal Division sits merely 12 kilometers away in Kampala with full infrastructure, security, record-keeping facilities. The sole circumstance that changed between 9th and 11th of April 2026 was the minister's public demand for a community trial. By relocating the High Court to the exact churchyard where the victims were mourned, the judiciary has converted a narrow legal discretion into open political obedience. This is not access to justice. It is access to a minister. The second offense of the judiciary is violation of the right to a fair trial. Under Article 28 of the Constitution, there is a guarantee of a fair hearing before an independent and impartial tribunal. A court deliberately cited at the scene of the alleged infanticide in a churchyard with the regulated access for representatives of the families, religious leaders and local leaders cannot possibly be impartial. The venue itself functions as evidence. The anticipated crowd as a witness. The church becomes the dock rather than a sanctuary. Article 28 3C guarantees adequate time and facilities for one to prepare their defense. What law library, what consultation rooms or confidential attorney-client spaces exist on open church grounds? The judiciary has taken their choice from a courtroom to a spectacle and labeled it transformation. The third offense by judiciary is the unacceptable obsequiousness and the collapse of judicial independence. Article 128 declares that in the exercise of judicial power, the courts shall be independent. Article 128.2 commands that no person or authority shall interfere with the courts. The timeline is damning. Minister Balaam issues a directive on 9th of April. ULS condemns it on 10th. Judiciary announces the mobile court in Ggaba on 11th. This isn't coincidence. This is command and compliance. The height of cynical interference lies here. The judiciary has allowed the executive to select the venue, the symbolism, the tempo, and the audience of a capital trial. Then dressed the surrender in the language of public interest and the transformational agenda. Mobile courts under legal notice number 1 of 2026 were intended for hard-to-reach areas, circuit backlogs, or natural disasters, not for high-profile murders 12 kilometers away from the High Court. To invoke taking justice close to the people in these circumstances is to launder executive interference as judicial reform. The fourth and final, security and decorum. A lynch mob invited by court order. The judiciary's own statement admits particular attention given to security considerations and the categorization system for attendees. While confirming live streaming to a wider audience, the court anticipates rage and therefore rations access and broadcast trauma. A trial is not a stadium event. When the judiciary must plan crowd control and overflow screens for a capital murder case, it has already conceded that it is no longer presiding over a judicial proceeding, but managing a flashpoint. We shall say more on this later today and throughout this week. I encourage you to book our officials for press interviews and talk shows and follow through on this discussion here. The statement is signed by the President, Isaac Semakade Chimaze, Senior Counsel, on this Sunday. You want to ask a question?
Counsel, what do you want as the Uganda Law Society?
What do we want as the ULS? Adam, I don't know if we have on call the President. He may want to answer that question there, even if I feel so ready with the answer.
Mr. Nangulu?
Yes, President. There is a question. There is a question from the media. From this statement, they ask.
Well, Mr. Nangulu, thank you very much for delivering my remarks, my prefactory remarks. To clarify the question, stay on the stand, Mr. Nangulu. My remarks are merely prefactory. I am prefacing the position of the bar as a whole. It was important to bring the 24-year history of the bar into the public domain because some people were not born 24 years ago. Some people don't have that memory. And I believe all the journalists in this room don't know Father Declan O'Toole and don't remember the Cotido case properly. So because in our final position, where we are going to give you what we want, this case is going to be spoken of as a matter of fact, as if it is part of your normal conversation. That's point one. Secondly, my remarks were merely prefactory in the sense that, again, this mobile court business has been presented to you journalists by the judiciary as their own innovation, and it's so new. And this is how, and the Chief Justice has no power. There are no limits to the Chief Justice's power to use the mobile court anyhow. He chooses randomly on whom to use a mobile court. No, that's not the intention. Okay? So what we want now is going to be said in our official statement. Just be kind and patient again. Maybe lastly, Adam, in your preface, you didn't really play the videos. There are two important videos. There is the video by the minister addressing UBC, and there's the video by the principal judge making remarks via NTV. You didn't play those videos. You spoke for them. Yet those videos speak for themselves. That's very important. If you can correct that record, it will be helpful. But otherwise, if Zanda is ready, Zanda, our council member for Central will offer the full answer. But Nangulu, use your discretion to see whether you hold your horses now to speak after Zanda or you answer it now. I leave it to you. I thank you for delivering my prefatory remarks with great solemnity and clarity. Thank you very much.
Thank you, Mr. President.
I will also be available for questions later after my brother, leader for the Central Region, has spoken.
Okay, thank you, Mr. President. Allow me, I will have that question answered after we have, because the answer is in the statement. I'm going to, allow me, we shall have questions flow after we have delivered the statement. I'm inviting our council member from the Central Region, Mr. Zanda Nkima, to deliver the Radical New Bars statement on the intended trial, the intended institutional mob lynching starting tomorrow, and what the Radical New Bars next course of action shall be. Mr. Zanda, you're most welcome. The media is eagerly and honestly, they've been waiting for you, please. The time is now.
Good afternoon to you, viewers, listeners, people present, colleagues, once again. The name is...
Zanda?
Yes, Mr. President.
If I may intervene, apologies. I think our Secretariat should give you the written record. I see you're using the...
It is being
phone record, yeah. Yeah, please. It's very important that you read from the signed record. You may read yesterday's version.
The name is... Thank you, Mr. President. The name is Rule Alexander Nkima, the acting central representative, ULS. This is our statement. Statement of position by the Uganda Law Society on the proposed mobile high court session in Ggaba for the trial of Christopher Okero Onyum. It is dated 12th April 2026, and that is today. The Uganda Law Society unequivocally condemns the judiciary's decision to convene the first mobile high court session in Ggaba Community Church grounds on 13th April 2026, that is tomorrow, for the trial of Christopher Okero Onyum, the suspect in the tragic Ggaba toddler killings that occurred on 2nd April 2026, that is 10 days ago, barely a week and a few days. What has been packaged as speedy justice in courts, speedy justice and enhanced access to justice still in courts. Under the Constitution, Operation of Mobile Courts Practice Directions 2026 is in reality the most cynical form of executive interference in the affairs of the judiciary witnessed in Uganda since Constitutional Petition number 2 of 2002, Uganda Law Society and Jackson Ggaba versus the Attorney General. This is not justice. It is judicial lynching rally, stage managed at the scene of the crime with the direct command responsibility of the executive and active complicity of the judiciary. The evidence of interference is overwhelming and brazen. On 7th April 2026, that is after 5 days from the occurrence of this event, of this massacre, Principal Judge Jane Francis Abodo publicly declared that the President says the case must be handled, and directed the judiciary to test the mobile court directive by taking the court to Ggaba and handle the case there and handle it fast. Those were the words of the principal judge, quoting directives from a fountain of honor. Minister of State for Youth and Children Affairs, Honorable Balaam Baruhagara, went further than this, addressing the Uganda Broadcasting Corporation, UBC, on 4th April 2026, that is 2 days after the incident. He dismissed human rights and all plausible defenses of the terrorist, who should be charged with premeditated murder, and declared that such suspects deserve death by shooting at a firing squad in full view of the public at City Square. Those were the wordings of the minister. Very unfortunate. While representing His Excellency President Museveni at the memorial service held at Ggaba Community Ministry Church compound on 6th April 2026, the same minister pronounced the suspect, he declared him, and he had already convicted him, as a criminal, even before his first appearance, that is, even before the suspect's first appearance at Makindye Chief Magistrates Court, which was on the 8th April 2026, where the accused was formally charged with the murder of the 4 toddlers. In a long post on X, formerly Twitter, on 10th April 2026, a day after the accused was committed to the High Court under visible harassment and dehumanization by security officials, the minister, that is Honorable Balaam, yes, that name. The minister announced the precise trial modalities as daily sessions from 9 a.m. to 4 p.m. starting on Monday tomorrow, 13th April 2026, with a limited seating of 1,000 people, giant screens and speakers for public viewing, live broadcasts on television, and the entire spectacle at the scene of the crime. The judiciary's own communique unsurprisingly came a day later, confirming it will stream the proceedings live to enable a wider audience to follow, while restricting access through a categorization system that prioritizes religious leaders, affected families, local leaders, and media, precisely the constituencies already inflamed by ministerial statements. This is not public participation. It is the weaponization of public grief to predetermine guilt. The minister's memorial service rhetoric, the president's direction, and the judiciary's eager compliance have fused the executive, the community, and the court into a single lynch mob. The presumption of innocence guaranteed by Article 28, Sub-Article 3, Paragraph A of the Constitution, Article 7, 1B as well, of the African Charter on Human and People's Rights, also known as the Banjul Charter, and Article 14.2 of the International Covenant for Civil and Political Rights, ICCPR, has been publicly executed before any evidence is tested. The ULS was neither consulted nor invited to participate in this rushed constitutional experiment. We do not support it. We reject it. In 2002, the ULS successfully petitioned the Constitutional Court to declare that even field court-martial proceedings conducted in the heat of public outrage violated the right to a fair hearing under Article 28 of the Constitution when they denied the accused adequate time and facilities to prepare a defense, an independent and impartial tribunal, and the right to appeal. The court held that the Constitution applies fully to every judicial process, military or civilian, and that it is not possible for Uganda military courts to be independent and impartial given the current laws and the military structure within which they operate. The same principle applies with even greater force here. A mobile court summoned to the crime scene at presidential command, surrounded by mourners, pastors, and live cameras, cannot possibly be independent or impartial. It is structurally incapable of delivering justice. The UN Human Rights Committee, in General Comment number 32 on Article 14 of the ICCPR, is explicit. The right to a fair trial serves as a procedural means to safeguard the rule of law. It demands an independent and impartial tribunal, equality of arms, adequate time and facilities for the preparation of a defense, and protection of the presumption of innocence from prejudicial pretrial publicity or public opinion. Public hearing may be restricted for reasons of morals, public order, or the interests of the private lives of the parties, precisely to prevent the kind of mob atmosphere now being engineered. The African Commission's 2003 Principles and Guidelines on the right to a fair hearing, to a fair trial, and legal assistance in Africa reinforces this. Judicial bodies must be free from inappropriate or unwarranted interference with the judicial process. And no accused person may be tried by a tribunal whose independence is compromised by executive direction or population pressure. The judiciary's ill-guided embrace of public participation in this matter fans the flames of judicial lynching. Notwithstanding the powers of the Chief Justice under Section 5 of the Trial and Indictments Act, Cap 25, or the Constitution, Operation of Mobile Courts Practice Directions 2026, the venue of any trial is a matter for judicial determination by the presiding judge. In fidelity to the sacred principles that justice must not only be done, but must manifestly and undoubtedly be seen to be done, the High Court is obliged to transfer proceedings to another place where an impartial trial cannot be heard in the original venue. So we ask, how can Justice Alice Komuhangi Kawuka This is what we ask. How can Justice Alice Komuhangi Kawuka credibly determine venue impartiality when the judiciary has already converged with the executive to announce Ggaba Community Church grounds before hearing a single submission? That is our question. The site was selected after a minister's directive, inspected by the deputy registrar, and advertised as historic before the file reached the judge. That is not judicial determination. That is autocratic instruction. When the executive chooses the dock, the judiciary builds it. The defendant is already in chains. Article 28(1) dies not in the judgment, but in the venue notice. By relocating the High Court to the church grounds where the victims were mourned, by installing screens for the crowd, and by scheduling a 1-week fast-track trial immediately after committal, the judiciary has transformed a solemn criminal proceeding into a public spectacle. The accused, already labeled a criminal by a serving minister and targeted for a swift and tough punishment, cannot possibly receive the fair trial guaranteed by the Constitution. Defense counsel will be forced to prepare under the glare of national outrage, with the entire nation watching live. Any perceived lenience will be met with accusations of judicial weakness. This is not access to justice. It is mob justice disguised in decorum. Why should this be of concern to Ogola in Busia, Okero in Kitugum, Bwambale in Kasese, and Namukasa in Masaka? This is not merely a single trial. It is a precedent in the making. The manner in which this case is conducted will define the template for future high-profile prosecutions. If constitutional safeguards are diluted under the pressure of public outrage and executive direction, such dilution will not remain exceptional. It will become the norm. We are not persuaded, nor should any rational observer be, that Christopher Okero Onyum will receive the assurance of a fair trial. The convergence of presidential directive, ministerial pronouncement of guilt, and a venue chosen for its emotional symbolism creates an environment of inevitable bias. The separation of powers, independence of the judiciary, and the rule of law itself are under direct assault. This is something we have always been singing all the time. The independence, the separation of powers, the independence of the judiciary, and the rule of law itself are under direct assault. The ULS, which in 2002 stood against executive overreach in the name of speedy justice, stands gallantly again against it today. We call upon the Chief Justice to immediately withdraw the mobile court directive in this case, to conduct the trial in the ordinary High Court premises in accordance with established rules of procedure, and to reaffirm that the judiciary serves the Constitution, not presidential instructions of public sentiment. The victims' families deserve justice. The rule of law demands it to be delivered fairly, impartially, and without theatrical flourish. Anything less is not justice. It is vengeance dressed in judicial robes. The Uganda Law Society will continue to monitor these proceedings and will not hesitate to take all necessary legal steps to defend the constitutional order. Issued by the Uganda Law Society Council this 12th day of April 2026 at ULS House, Kololo, now and today. Thank you. A brief translation into Luganda. Kakati kino kye kiwandiiko ekiraga obwennyamivu n'obutali bumativu bw'ekibiina ky'abalooya nga kikulemberwa akakiiko akafuzi ku nsonga y'ekkooti egenda okutuula eggaba okuwoza omusango gw'omuntu mwenna gwe mubadde mulaba ku TV ne mu mawulire gwe bayita Christopher Okero Onyum eyatta abaana 4. Ensonga eno yabeerawo nga 2. Okuwuliriza omusango ogwo kugenda kutandika enkya nga 13 nga waakayitawo ennaku 11. Tuzze tuwulira ebintu bingi ebyogerwa abakulembeze bye tulowooza nti tebyandibadde bituufu kuva mu bakulembeze abo. Ekisooka kye kya minisita atwala ensonga z'abaana Balaam Baruhagara eyavaayo omwami ono n'amusalirawo y'omusango yamuyita namutujju. In fact mu bigambo bye bu video tugenda buplayinga nga maliriza wano yagamba abantu bwe bati basaana kuteeka ku Freedom Square ne babakuba amasasi ne bafiirawo. Ekyo nno kyava mu minisita. Era ne tuwulira ebigambo okuva mu omukulu atwala abalamuzi ab'ekkooti enkulu Principal Judge Abodo Jane Francis nga naye agamba mu bigambo bye nti pulezidenti w'eggwanga yatugambye ensonga eno tugikoleko mangu, n'olw'ensonga eyo sipiidi eno yonna yonna gye mulaba eriwo lwakubeera okulagira n'ebiragiro bya pulezidenti. Tuzze tukinnyika nga tukyogera lunye nti ekitongole ekiramuzi kibeere nga kyeteŋŋenena, bakirekere okwemalirira kwakyo okukiweebwa ssemateeka. Naye enfunda nnyingi tuzze nga tulaba abakulembeze pulezidenti abakulu abo abagwa mu kkoweeri erya executive baminisita nga bavaayo okulagira ekitongole ekiramuzi n'okubaako bye babagamba okukola. Ne twekanga ng'ate ekitongole ekiramuzi tekiwadde ensala yeeteŋŋenedde nga bwe kirina okukolebwa mu ssemateeka. kale nno tubeera tugamba nti emisango gino gyandiwuliddwa mangu ku ssaawa eno kye bagezaako okukuwa ggwe munnayuganda yenna ali eyo oli musanyufu kuba olowooza nti ekkooti ekoleddewo abaana battiddwa mu nnaku 10 omuntu bagenda muwozesa. Mu mateeka tulina ekintu ekigamba nti ensala y'omusango erwawo omuntu obeera kwegamba tomuwadde kulamula kulungi. Kyokka ate era bw'oyanguya empoza y'omusango still era omuntu oba tomuwadde nnamula ya musango nungi. Abantu battibwa nga 2 omusango gugenda kuwuliribwa nga 13. Mu mateeka gwe nga munnayuganda olina obulumi kuba walabye ng'omusajja onatta abantu bye bitambula mu mawulire, naye omuntu oyo ayina eddembe okuwolerezebwa puliida, ayina eddembe okutegeka omusango gwe. Kale nno twebuuza bapuliida abagenda okuwolereza omuntu ono bagenda kukikola batya? Bapuliida tutera okubeera n'obuzibu bwe tuwolereza abantu bano, abantu abakulaba bo baba naawe bakusalidde dda omusango, naawe olinga omutemu oyo. Allegedly omuntu oyo ababeera bali mu muwozesa bazuula oba mutemu. Puliida aba akola ssemateeka kye kimuwa okukola. Kati teeberezaamu mu lujjudde lw'abantu puliida agenda kuwolereza atya omuntu ono ng'akola ssemateeka kyamulagira okukola ng'abantu bamuŋŋoola. Mu bantu abo bonna abajjudde already abaasalidde dda omuntu ono omusango. Kale nno amateeka mangi nnyo gazze googera ku bintu bino. Ffe ng'ekibiina ky'abalooya olw'okubeera nga twesigama ku nnamula y'amateeka n'enfuga y'amateeka nga gagoberebwa obulungi, tulowooza nti kino si kyakugoberera mateeka bulungi, era y'ensonga lwaki tuvuddeyo nga tuwakanya ensonga zino, era tusaba era tuteeka Ssaabalamuzi ku nninga ebintu bino bye yagambye nti abantu bano omuntu ono awolerezebwe mu lujjudde abisazeemu, omuntu ono ayite mu mateeka. Amateeka agalina okugobererwa gagoberebwe bulungi ewatali kyekubirira. Ffe tulowooza nti kuno si kuwa muntu ono bwenkanya, wabula bayina ekintu kye bakweka, waliwo ekintu ekiri mu kuyisibwawo kye tutannategeera, okulaba ng'ensonga zino baziddusa era bazikola mu ngeri eno bweti. Era kino kigenda kuteekawo akabonero nti mugenda kutandika okulaba ensonga n'emisango egijja olw'okubeera nga gavumenti ekiyinamu omukono oba influence, etandika okubeera ng'eragira nti omuntu oyo ke yakoze kino omusango gwe muwulirizeewo enkya. Kale nno mu bufunze byebyo ebiri mu kiwandiiko kyaffe kino ekyakoleddwa akakiiko akatwala bapuliida mu Uganda. Nga mmaliriza, mwebala okuwuliriza statement eno, nsaba ow'ebyuma bikalimagezi atuteereko obutambi bw'abantu bano nga boogera ebigambo bye tubagambye, tuleme kubeera nti tubawaayiriza. Please the IT team. Mobile courts ezo ziyina amateeka. Kale si budde bwa kibuuzo naye ekyo nakyo kankiddemu, ebibuuzo bijja kujja nga tumaze okuteekako bu video. Ne mobile courts ezo ziyina emitendera gye ziyina okuyitamu. Omulamuzi gwe bawadde fayiro agenda okuwuliriza omusango y'alina okusalawo w'alina okuteeka ekkooti ye ewulirizibwe. Waliwo emitendera egirina okugobererwa kye tusuubira nti tegyakoze eki, tegyagobereddwa. Kino ekintu kipya tekikolebwangako, tebakifumbye bulungi kukiteekateeka. Kale nno tulowooza nti ffe bakiddukidde era abantu tebagenda kufuna bwenkanya. IT team, please can you play the videos of Honorable Balam and the principal judge. Oh, I see. Okay. All right. Kale ebyo bijja kubeera byaffe abagoberera online. Kati I think Mr. IT, can you reconnect the president as we are going to the question and answer session? Adam, are you connecting the president? Can you please reconnect the president as we get to the question and answer session?
Maybe, thank you so much, Council Lule. Maybe as we await for President, we could be allowing 1 or 2 questions.
Okay, we can have questions. I do recognize the presence of our fellow council members who have joined us. That is the Secretary, Mr. Mr. Babu Sali, and Mr. Egaru Omiat, the representative of North. We can have the questions. We shall share them within us and give you the answers. Adam, can you please move the mic for any questions? Can you move the mic for any questions that are arising from the public? And in case we have no questions, thank you for being a good...
Okay, Council. My name is Farouk Kasu. I work with the New Vision. We want you to get clear on what Uganda Law Society want, because at one point we have members of the public that are very annoyed of what happened. Someone allegedly killing children that cannot even express themselves. By the same time, I know that you're losing a legal eye on these issues. So if you say that from the look of things, the judiciary lost this system and it may not reach the tenements of a fair trial, this trial is not going to stop, regardless of whatever you've pointed out. How best do you want the judiciary to conduct this trial the way it is, without at least to have a semblance of justice? Thank you.
Thank you. That is one question. Can we have other questions? Council members, we are going to answer those questions. We are going to share them. Any other questions? Or that is the only question we have? I will ask the Secretary, Mr. Babu, to give us an answer to the question.
I believe the question was in relation to what the judiciary must do, because you do not think the trial will stop and the condemnation or what ULS intends to achieve in what we have just stated today as our statement, and what you have also mentioned as probably what we think the public is expecting out of this hearing. However, as the Uganda Law Society, which is the national bar of Uganda, we are here to condemn the actions of the judiciary, which seemingly portray towards siding with the executive in the manner in which the trial has been organized. This mobile court system is one that was designed for access to justice and efficiency, but it is not one that is a stage or a sort of stadium managed activity. And therefore, by taking a member to the public that is hungry, you have deviated from the tenets of rule of law, the tenets of justice, that is under sections 28 of the Constitution of the Republic of Uganda, Article 28, Article 128 of the Constitution, and therefore, Uganda Law Society is here not to side with the accused, but rather to state that the Constitution is clear that every person has a right to a fair trial. And whereas it is before the public and the member is already judged as one who is guilty, the courts must not be seen to facilitate this. The courts must not be seen to aid what the members of the public and the executive are presuming, but rather the courts are there to offer dispensation of justice without leaning or deviating from the very principles that even put the courts in place. Thank you.
Thank you, Mr. Babu. To add a little to the answer he has given, Uganda Law Society is mandated to make sure the rule of law is enforced. And we believe by the judiciary setting this precedent, they are creating for us something we are going to have to suffer with the rest of our lives. This is how some of the normalities we are having that used to be abnormal have come. Given the fact that it is the executive that is influencing all this, and we already have a history of political persecution, and we believe the government or the executive will use such scenarios and these precedents to persecute whoever they have interest in. So the aggrieved, the people, the Ugandans that feel sorry for the losses of the kids, they are right. They have that right. However, we cannot allow an illegality to happen to correct something wrong. A wrong cannot correct another wrong. So that is why ULS is coming up as the holders and enforcers of the rule of law to come and speak for the public the reasons and the issues for whatever the judiciary together with the executive are trying to do. So that is the reason as to why ULS is coming up with whatever we are coming up with today. I don't know if any of my colleagues would want to add on that. Mr. Igaru, you can add a word.
Okay, thank you very much, Council Zanda and colleagues who are here. As you may be aware, as a society, our job is to set the record straight. And that is what we are doing, or we are trying to do. It is very important that the Constitution and the laws are followed regardless of what the executive thinks, regardless of the outcry of the public. What is the use of conducting a hearing which then can later be set aside? We have already talked about a case that is petition number 2 of 2002, where the Constitutional Court declared judgment and proceedings that took place in Cotido illegal. And so, as much as we are interested in seeing that the families who have lost their dear ones, our dear kids, where, as much as we want to see that court hears this case and pronounces itself for the families to get justice, in the same way we are interested in seeing that this trial is properly conducted within the tenets of the law. And so, as Uganda Law Society, as the Bar Association of this country, our duty is to guide the judiciary, our duty is to guide the executive. Our duty is to set the record straight. And so, I just want to add my voice on the voice of my colleagues that let the right thing be done. Let the Constitution be followed. That is what is most important. Thank you.
Yes.
I believe those are the questions. Adam, I pray that you reconnect the president so that we can wind up. Reconnect the president so that he can give us his remarks. Thank you.
Am I clear? Am I clear? Is everything fine over there? Can you hear me?
Yes, we can hear you, President.
Yes, Mr. President, we can hear you loud and clear.
Thank you very much. The question asked by my brother Farouk Kasule has received good responses from my colleagues in English. I may as well provide responses in Luganda. Muganda wange Farouk, tuli bennyamivu nti kooti kati ekulirwa Chief Justice Zeija ayakatuula mu ntebe tannaba na kugibugumya, etandise okukola bivvulu. Era yeegasse ne Ssaabavvulu emisango gya kkooti bagikolemu ebivvulu, ebbinu, enkuuka n'ebintuntu bwe bityo ebirala. Open court, kooti okubeera nti emisango egiwulira mu lujjudde tekitegeeza nti era giwulira mu kisaawe oba mu nkuuka oba mu kivvulu. Kasule tubadde ffembi mu mulimu guno okumala ebbanga. Gwe nga munnamawulire okiikirira public era courtroom number 1 kugeza maybe ogwa Besigye mu guwulirwa emala era ye courtroom omwawulirwa abalugogo bombing ogujjukira gwali musango munene nnyo gwa bannaggomola mulimu abantu abafa bali 79 twagenda Kyambogo olugogo nguwulirwa awo mu kisaawe. So tuli bennyamivu nnyo nti batugamba nti kati akulira kooti alina PhD kakensa mu bya judiciary ne human rights, naye atyoboola ennono zaffe nga bannamateeka era n'ez'abalamuzi ezawandiikibwa UN Human Rights Committee, akakiiko kabaka k'ensi zonna akayambako ensi zonna okutaputa endagaano y'ennono z'eddembe ly'obwebange eyitibwa International Covenant for Civil and Political Rights. Kayina ekitabo kiwandiise ejjuzu ku fair hearing bagiyita General Comment number 32. Ensonga eno yayogerwako. Gavumenti nyingi zandyagadde nnyo okuddayo mu nkola enkadde nnyo erabibwangako mu Europe. Mu Europe balina stadiums nga za kooti era ne mu Bible ndoza mukiraba nga Yesu Pilato, kooti ya Pilato. Naye bo bennyini bazikoowa ne Pilato yennyini yagamba Yesu gwe mundeetedde okugusalira bwe muti tekijja kukola. Zino si zennono za Roma. So kiswaza ono Chief Justice si Chief Justice n'akatono, ono kikwangala kiwoobu mu Luganda mukiyita ki, some GMO food. Kino kikwangala kicupuli kya Chief Justice. This is evidence. Kino kicupuli kya Chief Justice kye baatuwa era tuyina okukivumirira ne sekuvumirira yenna. Twabalabula ne sekulabula mu mwezi oguwedde tubagamba nti ono Chief Justice tumuseeko ebide nga buli wayita alinga kapa. Tulina kumwekengera buli kiwandiiko kyassaako omukono tulina kukyekengera nga bannansi, kubanga talina kirungi kyazze kukola mu ofiisi eyo. Kale nno ekyo njagala kyembaneesobola otegeere nti open court tekitegeeza kivulu. Kimala olujja okuluggula kooti eyingirwemu abanajjamu abatasobodde kujja balinde banaakeera enkya omulamuzi akole omulimu gwe ng'abalamuzi bonna mu nsi endala ne mu ggwanga lyonna nga talina bweraliikirivu ng'obwo kati bwe batadde ku ono nti alina okubeera omukubiriza w'ekisaawe, alina okubeera event organizer. Jjukira abantu abo bonna kati babeera under mulamuzi yaba akulira discipline ku bantu 1,000. Kati attention aba agijje ku musango agitadde mu security arrangements, enteekateeka za security ezaani ani gwe baganye ebyo byonna byonna bajja okubeeramu ku musango. Njagala tugende ku musango then. I think before we go to musango, kino ekintu kiraga waliwo ebigambo president byayogera ekisozi Chief Justice Soze yijanga agenza okulayira. President yagamba nti kati oluvannyuma lw'emyaka 4 judiciary ekomyewo wembadde njagala mu nkwawa zange temwakiwulira temwakitegeera naye ndoza bwe nkyogera mu Luganda bujjo kitegeera. The president uploaded judicial convergence at the occasion of Chief Justice Zeija's swearing in. What does judicial convergence mean? Nti judiciary ebadde yotongodde ebadde weerungireekaana nti yagala amaanyi agaayo yagala kutukolako biragiro kutussaako ekkomo ku buyinza bwaffe kati ekomyewo wansi w'obuyinza bwaffe. Era nfunye Chief Justice alina empisa ennungi atagenda kukola mpisa mbi ng'abalala, atajja kujeemera biragiro byange kusaba kwange. Mbadde mbonaabona ne ba Chief Justice abalala naye nfunye alikolerangawo buli kyensaba oba kyendobooza oba alineebuuzangako. Muntegeera bino bigambo president yabyogera in 2 words, but that's the meaning. Judicial convergence is the opposite of judicial independence. The president uploaded that in Zeija finally he had achieved judicial convergence. Kitegeeza ki omuntu wa bulijjo? Oyinza okulowooza nti bino bya misango giri high profile ogwange okutabamu president ebijja kunkwatako. No, presidency ennene, president akulira security apparatus yonna, intelligence, police, army, n'abakozi ba gavumenti. Abo bonna basobola okutuukirira omulamuzi yenna mu kkooti yonna, naawe ekuli okumpi ebigasa ebikomansimbi. Omuntu n'agamba nti nvudde wa president bino byonna byagala president angambye nkugambe okole bwoti guno omusango okole bwoti. So ekyo 1 2 balooya bangi batugamba nti alina okweraliikirira kungi n'obunyamivu bungi kubanga bwe babeera mu misango gye bayita crime gavumenti nga ekuguddeko omusango balaba nnyo abalamuzi okugeza kati ng'oyo omulamuzi w'Ekanyanya oba ew'Ekawempe Kasangati Nakawa ali mu misango gy'aba mu Fumbiro nga abalamuzi abo n'abawaabi ba gavumenti nga tebannajja mu kkooti bakola meeting n'abapoliisi n'abamagye n'aba security ne bateesa ku ngeri gye bagenda okukola omulimu gwa leero. Kati bwe tujja okwoza tuba tuyise tusabye eggulu bali bakkaanyiza dda ekigenda okuva mu kkooti. So abalamuzi bangi naddala abato tebalabanga nkola ndala era balowooza kya bulijjo. So kati tukabye mu lujjudde nti ye polisi nti kkooti nga talina tuyita kuwoza eba yatudde dda ne Museveni ne baminisita be ne security apparatus. Era bw'osoma ebbaluwa ya post ya minisita Balamu akulaga nti tugudde mu meeting ebadde nnene. Njagala okusooka okutuusa okwebaza kwange eri ba security chiefs. So akulaga nti wabaddeyo meeting ey'aba security chiefs, ey'aba prosecutor, abawabi government, ebaddemu ne chief justice era naye amwebaza ne chief justice abadde mu meeting yaffe n'akkaanya naffe engeri gye tugenda okukola ebintu bino. Balamu atulaze bulungi nnyo era tuli basanyufu nnyo nti evidence Balamu amuleese mu lujjudde. Nammwe bannamawulire mulina okumutegeera cause mmwe bakalabalaba b'omuntu wa bulijjo. Kakati njagala genda ku ekyo ky'okonyeeko nti naye omusango buli omu yagulaba mu lujjudde. Ono talina mpoza. Lwaki tumala obudde n'ebintu ng'ebirala? Lwaki abantu tuba wassanyu? Enjogera eyo erina obuzibu bungi bannange bagikonyeeko, naye njagala okugumikiza ebintu bibiri oba bisatu. Ekisooka nti kasita tukola ensobi netugamba nti gwe tukwatidde mu nsobi mu lujjudde tumukwasa na gavumenti tumutuusaako ennono zaffe awo wennyini ewatali kulwisa, tuba tuvudde ku nnono z'amateeka. Tuba tuvudde ku nnono z'amateeka nga tukkiriza nti abantu ba bulijjo balina okutwaza amateeka mu mikono gyabwe, oba abakozi ba gavumenti tubassaako obukwakkulizo bungi nabo sinsi bakwasa amateeka tebalina tuziyizibwa. I think that's what the minister said. He said be human rights biki byakutuziyiza. Investigation zaawedde dda, teri mulamuzi kyagenda kukyusa. That's very important. Balamu said it and that's the feeling mwena gye mugguze. Ekyokubiri, kale omuntu yenna atagenda nko mu kkooti oba atajja mu kkooti bulijjo ayinza okuba n'endobooze era akkirizibwa okuba n'endobooze ye, naye si gwe mulimo gwaffe balooya nammwe bannamawulire omuntu wa bulijjo okumusigazamu mu ndoboozi eyo. Era ssemateeka ekiwakanya. Mu ssemateeka mulimu kye bayita duties of a citizen, paragraph 29. Kangisome otuwulire bulungi kyegamba nti bw'oba yakubeera munnansi olina omulimu omunene nnyo ogusooka ogw'olubereberye gwe kalabalaba wa constitution eno. You must acquaint yourself with the provisions of the constitution and uphold and defend the constitution and the law. Gwe kalabalaba wa constitution, gwe asikali wa katiba. Constitution eno gwe munansi gwalina ogirwanirira. Museveni tagenda kulwanirira constitution, Museveni agenda gityoboola. Omulamuzi tagenda kulwanirira constitution, abalamuzi bagenda gityoboola. Bo bali bakozi ba ssente. banoonya byabwe bugagga na kwera abaana ba. So constitution eno yeyamba gwe munnansi muntu wa bulijjo gwe munnamawulire gwe looya. So nti gwe olina okufaayo nnyo okumanya buli nnyingo mu constitution ekyetegeeza na lwaki baakiteekamu. Bw'onoolowooza nti nnyingo zino biziyiza bitumalira budde, olikiraba nga kikutuuseeko. So that's the you have to bring to the attention of your audience. The second thing is that court proceedings, emisango gino, court proceedings are every day man's classroom. Omuntu wa bulijjo ayiga bingi mu nsonga n'amawulire agavudde mu kkooti buli lunaku. Nze bwe mbeera nga ndi musomesa mpumuddemu ekawungeezi ne nteekako leediyo yange, TV yange, ne nsoma amawulire, ne ngenda ku ssimu yange, bwe mpulira ebyavudde mu kkooti nga bikwata ku abo okugeza abasawo, njiga bingi. Njiga for instance amateeka abasawo gye balina okugoberera nga ngenze mu ddwaliro, nga sinnagenda mu ddwaliro. Bwe mpulira nga omusango gukwata ku byanfuna, biashara, contract, endagaano, njiga bingi so proceedings are not to be rushed because they are valuable even to non-members of valuable even to non-parties. So between no era amateeka bagawandiika bwe gatyo eddeko nnyo nti investigations zikoleddwa mu
we are no longer getting the president. I don't know whether he's done. Adam, is the president done? Or there was a problem with the network? Okay. As you're getting him back, we are about to wind up so that we can let the press go. We do appreciate you. Thank you for being patient with us and always turning up whenever we call. Thank you very much. Once again, the viewers, the attendees, and the colleagues, greetings from the President and the ULS Governing Council. We call it a day. Have journey masses. Thank you very much.
Yeah, sorry, I lost you there.
We are going to send you the money. We are going to send you the money account that you say you are going to Shamshad will send the money. Let's pass it because on I listen and